Let's welcome Jennifer Mora, Labor and Employment Senior Counsel, and Pamela Devata, Labor and Employment Partner at Seyfarth Shaw LLP. Jennifer is a nationally recognized expert on employment purpose background checks and regularly advises employers and consumer reporting agencies on the intersection of federal and state background check laws. A prolific author on cutting-edge background check issues for employers, Jennifer regularly speaks at industry conferences about employment screening. A nationally recognized employment counselor, Pam leads Seyfarth's nationwide background screening, litigation, and compliance team. She's a national authority and firm go-to for all issues related to FCRA, background screening compliance, use of criminal and credit history, and electronic signature issues, as well as online and manual employment applications. Rise Above 2020 is proud to have Jennifer and Pamela present on the topic Background Screening Best Practices.
Hi, everyone, and welcome. We are thrilled to be here today. My name is Pam Devata, and I'm here with my colleague, Jen Mora, and we're so happy to be here with Neeyamo and Rise Above 2020 Background Screening Best Practices. Because we've got limited time today, we're going to go ahead and dig in, and we'll start our slide presentation. What we're really going to be talking about today, if we can go to the next slide, is responsibilities under the Federal Fair Credit Reporting Act. And for those of you who do operations in the United States, there are really four main responsibilities that employers have under the FCRA. This is a federal statute that was put in place many years ago. And the four specific responsibilities that an employer has: number one, they must have a permissible purpose to run a background check. Usually that's going to be an employment purpose. Please understand, though, that we've got two regulators, the Federal Trade Commission and the Consumer Financial Protection Bureau, and they believe that employment purposes is very broad. So could also include things like volunteers and independent contractors, or what we see a lot, the gig economy. So you must have a permissible purpose to run a background check. We are talking about the employment permissible purpose. And if you are going to be running a background check for anyone who is applying for employment or who is an employee, you must then have a standalone disclosure and an authorization. I'm going to be talking in detail about those requirements because that's really the area where we have the most litigation. We've seen a huge increase in litigation in the last 5 years, specifically all over the country, but primarily in California as well. Then Jen is going to switch gears and talk about adverse action process. This is the third responsibility under the Fair Credit Reporting Act. If you are going to take action in whole or in part based on any information in a background check or a consumer report, you have to follow this sort of three-step adverse action process that Jen's going to talk about. You must then certify that you're going to follow all of these things to your background screening company in an agreement, and that you're going to follow any EEO, Equal Employment Opportunity laws and regulations. So as you'll see, these four main things that you're going to have to do as an employer are very important. The reason they're very important is because the liability under the Fair Credit Reporting Act can be very, very large. Specifically, the statute of limitations is the earlier of 2 years or 5 years. So 2 years from the date the person knew or should have known, or 5 years from the date of the consumer report. And the reason why it's so important to make sure you comply with the law as an employer in the United States doing business in the US under the FCRA is because the statutory damages can be exponential. Someone can sue you on negligent noncompliance or willful noncompliance, and the statutory damages can be $100 to $1,000 per violation. So let's go ahead and dig in on this first bullet, which is disclosure and authorization. If we can go to the next slide. These disclosure claims are really on the rise. And specifically, what the disclosure responsibilities under the Fair Credit Reporting Act are detailed. I'll ask the moderator if we can switch to the next slide, please. What happens is that disclosure claims have been litigated throughout the country, again, starting in 2015. And the problem is that the statute requires that prior to you running a background check for employment reasons, you must provide an employee or an applicant, and you must disclose to them in a specific document the fact that you're going to run a background check. But here's where it becomes really important. This document must be a standalone disclosure that consists solely of the disclosure, separate and apart from anything else. It cannot be part of the application buried in a paragraph. It cannot be part of other one large document, for example, that appears on the screen. It needs to be a document that is standalone, that is separate. And there's been a lot of litigation about this exact fact, starting again about 5 years ago and continuing to today. Our firm ourselves handle at least, right now, we're currently handling about 40 class action lawsuits just on this issue alone. And there are many, many others throughout the nation. The other thing that the statute requires is that you obtain written authorization prior to getting a background check. Now, what's very confusing is the statute says that the standalone disclosure must be, again, standalone and separate. But in the very next sentence, it says that that written authorization can be part of that same form. Tremendously confusing, which has caused so much litigation in this area. If we go to the next slide, we're going to talk a little bit about two of the most recent cases that have come to light. These have been in the Ninth Circuit Court of Appeals in California. One was last year in 2019, Gilbert versus California Check Cashing Stores. And then here just in 2020, earlier this year in the spring, the Walker versus Fred Meyer case. What did we learn from those cases? Well, specifically, we learned that if you have any extraneous information whatsoever on your forms, you are likely going to be sued. We're going to talk about at the end of our presentation some best practices tips to make sure that you mitigate your risk. One of the very most important of those best practices is to make sure that you have your disclosure form separate from anything else. Make that disclosure form separate and apart, even from the authorization. So have that form be by itself, not part of any application, but by itself, not even part of any authorization either. Anything that is surplusage or that is extraneous in that form will be challenged and is potentially likely unlawful. What we learned from these two cases that references to inspection of files or the notice and scope, for example, of an investigative consumer report are not going to be allowed. Just as a reminder, while it's called the Federal Fair Credit Reporting Act, that's a little bit of a legal misnomer, right? The Federal Fair Credit Reporting Act applies anytime that an employer gets any information that bears on somebody's character, general reputation, personal characteristics, or mode of living that you get from a third party. So criminal background information or motor vehicle records and the like are going to be contained in what a background check would be and what the Fair Credit Reporting Act is going to cover. So when you get this disclosure form, investigative consumer report, by the way, the difference between that and a garden variety consumer report, that's going to be when people get information, when a consumer reporting agency gets information based on personal interviews, for example. It could also be credit checks. That's not investigative, that's a garden variety consumer report. If you've got discussions of throughout your employment on the disclosure form, that potentially could be extraneous information, and you want to be careful about that. Having references to state law may be extraneous. In addition to the federal law, there's about 14 different distinct state laws that have their own requirements and responsibilities. So for example, in California, you have to have a different standalone disclosure form. And there's many other of these requirements, but you don't want to put that information on the standalone disclosure. Have another page, other state law notices, or have that be on the authorization, but don't have it be on the disclosure form itself. You can say that you're doing this for an employment purpose, and indeed in California, you have to say that as part of the statute. You can provide these documents at the same time that you provide hiring documents, but please be careful, because anything that is going to be combined or deemed to be part of the same document potentially is going to be a violation of the statute. And again, finally, in terms of disclosure and authorization forms, the authorization form doesn't need to be separate from other employment documents, just the disclosure form. I'm going to turn it over now to talk about, to Jen to talk about the next topic, which is adverse action. If we can go ahead and go to the next slide.
Thanks, Pam. It's really good to be here. Thanks, everybody, for attending. So Pam talked about the process for actually getting a copy of a background check report from a third party. And what I'm going to be talking about the next slides is what do you do if you get information in the report that is potentially disqualifying or might result in somebody not getting hired. Before I go into this process, I want to be clear that this process that I'm about ready to describe does not just apply to job applicants. If you find out that a current employee has issues in their background check, maybe you're running background checks during employment and you decide something has come up that might result in their termination, you have to follow the same notice process for existing employees. So don't just limit it to the job applicants. Adverse action is defined broadly. The FTC, as Pam mentioned, pretty much takes a broad view of most of the terms in the Fair Credit Reporting Act. But an adverse action in employment context is generally going to look like rejecting a job applicant for a job, withdrawing their offer, or like I said, if you have an existing employee, maybe you're going to demote them, maybe you're going to terminate them. Anything that is considered adverse to the interest of the person is going to trigger this process. Before you take the adverse action, you have to provide the person, the applicant or employee, with a pre-adverse action notice. And this includes a full copy of the background check report, the FCRA Summary of Rights, which if you don't have that, you can get it at the Consumer Financial Protection Bureau website. Make sure you have the most recent copy. There's a lot of old ones floating around. And then any state and local notices. There are some jurisdictions that do have requirements that you have to actually identify the reason you're taking the adverse action, or you might have to identify the conviction. We're talking very broadly here about the Fair Credit Reporting Act, which doesn't say you have to say in the pre-adverse, and oh, by the way, it's because of this robbery conviction from 5 years ago. You just give them the report and the FCRA Summary of Rights. Keep in mind that the purpose of this process is to provide the person notice that they might be losing out on a job opportunity because something that's being reported about them and maybe they don't know about it. We like to kind of liken it to a due process for this person so they can let you know in advance if there are any issues before they lose that job. If we could go to the next slide, please. Once you've provided that notice, the Fair Credit Reporting Act requires that you wait a reasonable period of time. As I mentioned, this is to allow them to consider what's being reported about them, let the background check company know if there are any disputes, let you know if there's anything that they would like you to know about their record. Maybe they have been in rehab, maybe they had a really great work history since then, maybe they want to just tell you whatever it is that resulted in the issue that's causing you concern. You want to give them that opportunity before you withdraw the job offer or terminate their employment. The Federal Trade Commission has opined in an old opinion letter that 5 business days could be okay. That's typically our rule of thumb, so to speak, for lack of a better term. It might always vary depending upon your unique situation. You want to keep in mind mail period. There have been plaintiffs' attorneys who have claimed that if you put a background check report in the pre-adverse in the mail, then that eats 2 to 3 days, depending on where they live. So you're going to want to make sure that you're building mail period into your waiting period. And you're also going to want to make sure that you consider any unique jurisdictional requirements. Just a few examples: in New York City, you have to wait at least 3 days from the day they receive the report. But also keep in mind that the FCRA is going to want you to consider probably about 5 or more. San Francisco is 7 days. And during this waiting period, it's very important to know that you cannot take the adverse action during this period of time. You should not be communicating anything to the applicant or employee to suggest that any final decision has been made. If they call you and start harassing you, what's going on? I need to start working. I filed a dispute, what have you. You need to just be patient with them and also let them know to be patient, that you're investigating. No final decision has been made. It's very important. It's really easy to kind of mess this process up, during this waiting period. On the next slide. Okay, so you sent your pre-adverse, you gave them the report and whatever notices you have to give, you waited the reasonable period or whatever period of time you're supposed to wait under state or local law. What do you do now? If you've made the decision at this point that we're still going to withdraw the offer or terminate their employment, you have to send them a second adverse action notice. And this is the notice that is actually going to let them know that, yes, we have made a decision to withdraw the job offer or to terminate your job. The Fair Credit Reporting Act lists out on the slide the specific information that has to be included in the adverse action notice. You're going to want to identify the name, the address, the phone number of the background check company that provided the report. It might be obvious on the report, but you still have to list it out in the letter anyway. A statement that the background check company was not the decision maker and can't give reasons why the decision was made. We don't want background check companies called all day long asking about hiring decisions because they don't know. They get a right to obtain another free copy. Yes, we gave them a copy with the pre-adverse, but we still need to advise in this notice that they have another right if they want to get it again. And the most important part too is the right to dispute with the background check company. And they might have already filed a dispute during the waiting period, but you want to advise them more formally in this notice that they have that right. If somebody files a dispute during the waiting period, the FCRA doesn't specifically say you have to wait to see how the investigation with the background check company plays out, but we suggest that you do wait for a couple of reasons. Sometimes these disputes are correct, and background check companies are pretty good about turning around their reinvestigations in a short period of time. So if you have a particularly good candidate and they make, they've submitted a dispute that sounds reasonable to you, then you can definitely hold the position open for a little bit. But again, this is really going to depend on your unique circumstances. State and local notices, again, there are some states and cities that have what we call ban the box laws. I'll talk about this on the next slide, that say that you have to include certain notices. California requires in your adverse action notice, if the decision is based on criminal history, that you advise of their right to file a complaint with the Department of Fair Employment and Housing. Philadelphia, you have to give them another copy of the report, even though, yes, they got one with the pre-adverse, they get another one. And we recommend that you do this in writing so that you avoid disputes and that you ensure that all of the requirements under the statute and state and local law are covered. Next slide, please. Okay, and just a couple of things. Pam and I have been doing a lot of webinars that we could talk about these subjects for hours. And so we're really just trying to give you kind of high level things to think about in terms of issues in the United States. One thing is the Equal Employment Opportunity Commission issued in 2012 its enforcement guidance on employer consideration of convictions and arrests. And without going into too much detail, because the guidance is about 60 pages long, high level, we suggest you not consider arrest. The EEOC frowns on it. And if you're going to take action because of criminal history, a conviction, you're going to want to do an individualized assessment. One thing to note is that there are actually, while the guidance is just guidance, it's not strictly the law, there are some jurisdictions, New York, California, Wisconsin, where you do have to do a pretty specific job-related analysis before you reject somebody with a conviction. Ban the box laws, those refer to a movement that started back with Hawaii and Massachusetts, where the state legislature said, we don't want employers asking people, have you been convicted of a crime on an employment application? So we now have this trend that's been sweeping the nation the last decade, I would say, that is requiring employers to wait until much later in the process to ask about criminal history directly. So the EEOC would recommend that you wait until after an offer anyway in all jurisdictions. Some jurisdictions are going to require that. Some ban the box laws have notice postings. Los Angeles and San Francisco, you have to post city notices on the walls. Job postings, some laws say you have to have specific information in your jobs. And then some of them have substantive requirements. For example, San Francisco and Philadelphia, you can't consider convictions older than 7 years, even though at a statewide level, you can. Finally, credit check laws, we are starting to see some movement on that. I would say there's about a dozen jurisdictions across the country, plus DC and Puerto Rico, that have very substantive restrictions on what employers can consider in terms of credit reports and credit information. So you're going to want to make sure that you're mindful of those laws. And with that, I'm going to turn it back over to Pam, who's going to give us some takeaways for you to consider. Pam?
Thanks so much, Jen. And if we can, I see we have the next slide up, which is great. So here's what we want to really do and make sure that if you've learned nothing from our presentation before we get to the questions, what you really want to make sure is that you absolutely audit your forms and your processes, at least on an annual basis. We generally recommend that you have your disclosures and your authorization forms looked at least annually, or every 6 months is even preferred. That you make sure that your pre-adverse action and your adverse action notices, as Jen indicated, are reviewed by counsel that know what they're doing. There are a myriad of different state and local jurisdictional laws that are very complicated with the ban the box laws, specifically in terms of the timing and what information you need to have in those forms and documents and how you need to proceed, so that you don't put yourself in large amount of risk. And also as it relates to your job postings. We didn't really cover it today because it's outside of the federal standpoint, but there are many state and local jurisdictions that have prohibitions on what you can ask about in terms of criminal history and when you can ask about that, and what you can even put in your job postings or advertisements. So for example, New York City, you're not allowed to say that the job is contingent upon successful completion of a background check, for example. You also want to make sure you understand when and what you should be asking about criminal history and what you should be looking at. As Jen indicated, the EEOC criminal history guidance really talks a lot about this. So really only consider the criminal history that matters to you. If somebody's not driving for you, then basically looking at a driving conviction may not be job related and consistent with business necessity. So you certainly want to understand your rights and responsibilities under the law. Make sure you take away that criminal history question from your application. We think it's a very good idea, and we strongly recommend you actually put that information in your conditional offer letter or after conditional offer of employment, but not in your application. Train your managers and recruiters to understand the responsibilities under the Fair Credit Reporting Act, under the state and local ban the box laws, what adverse action is, what it's not. We like the no good deed goes unpunished, as Jen was talking about. You get a background check in on a Friday, you call the person in who's supposed to start on Monday, and you say there's a problem with your background check. Well, as Jen indicated, that is broad enough to potentially be adverse action. And right then and there, you could, even if you have a great policy, you could be in violation of the FCRA. And because this statutory schema is so ripe for class action litigation, it's very important to make sure that you understand what your responsibilities are under the law, so that you don't get sued on a single plaintiff or a class action basis. And then finally, make sure that you understand how to do an individualized assessment of the information. What that means is when you get a background check back, you shouldn't have a bright line rule, right? You shouldn't have a check that says, we don't hire felons, or anyone with a criminal history, we're not going to hire. As we talked about, the EEOC guidance talks about that could be a disparate impact, and that could have disparate impacts on certain minority groups, such as African-American individuals and Hispanic individuals, and be ripe for litigation under Title VII of the 1964 Civil Rights Act. There's also additional state laws that have those very specific requirements that you do an individualized assessment. So New York City, LA, and many, many others. And we're just at the tip of the iceberg in terms of that, for that information. So with that, we've got 5 minutes left of our session. And so we're going to go ahead and start looking at the questions. And I know we've gotten a number of questions in so far. If we want to go to the Q&A slide, I'm going to tee some of these up. If you do have a question, please go ahead and put it in the widget. As we've talked about before, any one of these topics could be over an hour presentation, and so we are doing a high level today. First question, how should employers handle court closures when they need to access criminal records? It's a very good question, especially in light of COVID-19, and we've done a lot of webinars and had conversations with employers on this. The key really is going to be, what you may want to do in your offer letter is indicate that you're going to run a background check, and it's going to be contingent upon successful completion of the background check. You heard me say in the offer letter, right? After you've provided that offer. And the issue there is going to be that you want to let them know that if a court is closed, for example, or you can't get information due to the pandemic, you're going to be running those checks when the court's open. So you need to make sure that you have a methodology with your background screening company, that you understand that what courts are open, what courts they cannot complete, for example, and that you have a methodology if someone is going to start work, that you check, for example, that information after the fact, after they start working. We get lots of questions on whether or not you should start a person, for example, prior to their background check being completed. And the general best practice is that you should not start a person prior to the background check being completed, if at all possible. And the reason for that is it is much easier to reject someone from employment than it is to fire the person. And think about it. A person, once they start in your facility, has access to your people, to your property, to your customers. And as Jen was saying, you still are going to need to follow the adverse action procedures, because adverse action applies to employees as well. So what that means is if you have someone started and then you get a background check back and you have to remove them from work, you can't just remove them off the spot. You have to give them the pre-adverse action letter. And if you remove them from work without paying them, that potentially could be adverse action. So you have to do the consideration of whether or not you keep that person in working, or if you take them out of work and you have to pay them for that requisite period of time, whatever is reasonable, 5 business days or whatever that reasonable period of time is. All right. Another question, what do you see as the biggest and current identity verification challenge at this stage of the COVID-19 crisis? You know, obviously we're in a digital age. We're all doing this via Zoom and other web services. And so, you know, you want to make sure that you are doing the same background checks and making sure that you are able to verify someone's identity, so there is not identity theft issues going on. What we certainly see is that things like running background checks, including social trace information, and getting information about an individual are going to be very, very important. The next question I will ping to Jen, and I'll weigh in as well. But this third one is companies have always found keeping track of changing compliance rules and the different regulations challenging. What can you do to keep abreast of different changes to the law? And are there technology tools that might be able to help? Jen?
Thanks. I'm not aware of any technology tools, and I think that even as the legal experts on the subject, so to speak, Pam and I even have a hard time sometimes keeping track of things. But, you know, we put out client alerts, and there's always somebody out there writing on something. And unfortunately, you know, what you could consider doing is once or twice a year doing kind of a legal spring cleaning and looking out there to see what's new, doing audits of your forms to make sure you're on top of things. And like I said, we're constantly putting out client alerts with respect to anything that's new, whether it's a case, a ban the box law, a state statute, what have you. And so those are good ways to keep on top of it. And a lot of background check companies too, they might have really good, in terms of the technology-based tools, they might be developing, probably getting better on that issue. Pam might have more on that.
Sure. Yeah, I think that's right. I mean, coming to, you know, conferences such as Rise Above and other webinars, making sure that you are keeping track of those things, going to industry conferences, those types of things are going to be really crucial to make sure that you're staying abreast of the ever-changing laws that you have right here as well. And they really are changing all the time. Jen, and my entire practice is compliance and litigation, and really defending companies and employers and background screening companies when they get sued, and not for nefarious, but when they get sued for highly technical violations, because this is a very, very technical statute with very highly technical terms. And that's certainly why we're doing this presentation today. And I think at that point we are winding down. And I don't see any other questions that we really haven't tried to address. So thank you everyone so very much for joining us today. We were thrilled to be here, and we hope to see you at another conference very soon. Thanks very much, everyone.
Thank you, everybody.